Welcome to Private International Law, Part 1. Private international law, which is also referred to as conflict of laws, is an important area of legal practice in international business and also presents a number of intellectual challenges that are not always easy to solve. Questions of private international law come up as soon as you engage in cross-border transactions, which is of constant occurrence for most enterprises today. As an illustration, I invite you to consider the following example. In this example, we have a Swiss company XSA that enters into a contract with an Indian business partner, Y Limited, based in Jaipur, India. The contract is about XSA delivering a machine to Y Limited for a price of $5 million. As you can see, this is a typical cross-border transaction, and it leads to a potential conflict of laws between Swiss law and Indian law. The questions that arise in that kind of cross-border transactions are namely the following. Is the contract governed by Swiss law or Indian law? Will disputes arising out of the contract be litigated in Switzerland or in India? And will a Swiss judgment be enforceable in India and vice versa? This is the program that gives you an overview of the topics we are going to address. First, we are going to have a look at the notion, the main issues, and the sources of private international law. Second, we are going into how to deal with conflict of laws issues, how to apply private international law rules. In a third step, there will be a special focus on renvoi, which is a widely discussed private international law headache. As you will see in this podcast series, private international law is a rather demanding field of knowledge. Issues of conflict of laws are quickly becoming entangled and complicated, which is why I think that you will need your full concentration to understand how private international law actually works. It will be a bit of a challenge, but I promise you that I will try to explain things as clearly and as comprehensible as possible. I will also try to put some magic into it. There might even be some ghost hiding inside to come out and catch you when you are not concentrated enough. But don't be too afraid of the ghosts. They are quite friendly most of the time. What is private international law? Private international law is part of what legal experts need to know in an increasingly globalized world. But we have to distinguish private international law from comparative law, and namely from public international law. Public international law and private international law are entirely different areas of international law. Public international law regulates primarily relations between states. It is based on international rules, mainly contained in treaties and international customary law. In contrast, private international law regulates conflict of laws issues in the field of private law. It is primarily national law that deals with international situations with cross-border transactions. And this means that every country has its own private international law. In Switzerland, private international law became codified in the 1980s. Before that, it was a field of law dominated by extensive case law, which was extremely difficult to master. It was the domain of a small group of specialists who claimed it as their secret science and who made pretty good money out of it. Codification led to a kind of democratization. Private international law became accessible to a wide range of legal practitioners. The Swiss Code of Private International Law was born out of a draft by Professor Frank Fischer from the University of Basel. The code features a clear and well-organized structure. In many ways, it is quite an impressive piece of legislation. The code was adopted in 1987 and it entered into force in 1989. It offers a comprehensive set of regulations containing some 200 articles and covering all areas of private law, including family law, inheritance law, property, contracts, corporate law, intellectual property law, etc. Even though private international law is primarily national law, there are also some treaties coming in. A number of such treaties have been put in place by an institution based in The Hague, the HCCH, the Hague Conference on Private International Law, that is currently headed by a Swiss, Mr. Christoph Bernasconi. The so-called Hague Conventions include, among others, the Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil and Commercial Matters, the Convention on the Protection of Children and Cooperation in Respect of Inter-Country Adoption, the Convention on the Civil Aspects of International Child Abduction, and the Convention on the Conflicts of Laws relating to the form of testamentary dispositions. The Hague Conventions are of special importance for the fields of family law and inheritance law, but they also play some role in more business-related matters. This video that is worth watching provides an interesting introduction into HCCH and its activities. A treaty that is central for cross-border transactions involving Switzerland and other European countries is the Lugano Convention, whose full title is Convention on Jurisdiction and the Recognition and Enforcement of Judgments in Civil and Commercial Matters. A convention that originally has been adopted at an international conference held in Lugano in 1988. And whose current version dates back to 2007. The background of the Lugano Convention is the Brussels regulation that regulates jurisdiction and enforcement issues between the member states of the European Union. In its first version, the Brussels regulation goes back to the 1968 Brussels Convention, and the 1988 Lugano Convention is in fact just an extension of the geographical scope of the Brussels Convention to some other countries, namely Switzerland, Norway and Iceland. In its text, the Lugano Convention was just copy-paste of the Brussels Convention. It's identical. The current version of the Lugano Convention, dating back to 2007, is just copy-paste of the 2001 Brussels regulation. In the next step, we should take a closer look at the range of conflict of laws issues that are regulated in the Swiss Code of Private International Law and in the treaties referring to private international law. The first of those issues is jurisdiction, which is about the competence of national courts. So for what cross-border situations do national courts have jurisdiction? Jurisdiction is an important starting point because it determines the lex fori, the law of the place of trial. And the lex fori is important for procedure, the rules of procedure, and it is also important for private international law, namely determining the applicable law based on private international law rules. A court that admits its jurisdiction would resort to its own lex fori, its own private international law rules, in order to determine the applicable law. This leads us to the next issue, the applicable law, the law that applies to the case. So which national law applies to what cross-border situation? This is what we also refer to as the lex causae, the substantive law applying to the case. A third issue is the recognition and enforcement of foreign judgments. So what are the conditions for a judgment being recognized and enforced? So this gives you the overview of the conflict of laws issues, and in practice they have to be examined in that order. First, jurisdiction, second, the applicable law, and third, recognition and enforcement of foreign judgments. Those issues are also reflected in Article 1 of the Swiss Code of Private International Law that defines the scope of the code. According to Article 1, the code governs, in an international context, the jurisdiction of the Swiss judicial and administrative authorities, the applicable law, the conditions for the recognition and enforcement of foreign decisions. In addition, it also regulates bankruptcy and composition agreements. And finally, international arbitration. According to paragraph 2, international treaties take precedence. Jurisdiction. This is about the question of whether Swiss courts are competent to deal with a case. But what about the competence of courts of other countries? Well, this is not a question of Swiss private international law. Whether the courts of another country are competent to deal with a case is a question of the private international law of that other country. The applicable law. This is about which substantive law applies to the case. It's about the lex causae. Now, depending on the case, the law that is applicable according to the Swiss Code of Private International Law can be the law of another country. And in such a situation, we would have a Swiss court that has to apply foreign law, which might be a bit of a challenge for Swiss judges. In order to help the courts in their challenging task of applying foreign law, the Swiss Institute of Comparative Law has been established. This is a federal institution that is located on the campus of the University of Lausanne. And the mission of the institute includes delivering legal opinions for courts. So when a court faces the challenge of having to apply foreign law to a case, it has the option of requesting a legal opinion from the Institute of Comparative Law. The Institute also runs a huge library featuring law literature from all over the world. It's a public library. It's a wonderful place to do research. So whenever you happen to be in Lausanne, pay a visit to the Swiss Institute of Comparative Law. Recognition and enforcement. So which foreign decisions can be recognized and enforced in Switzerland? And again, of course, the enforcement of Swiss decisions in other countries is not a question of Swiss private international law, but rather a question of the private international law of the country in question. An important limitation to the scope of the Swiss Code of Private International Law is that international treaties take precedence. So whenever there is a treaty that regulates an issue, the treaty applies and not the Swiss Code of Private International Law, which is why in practice we have always to check treaties first. And what about the scope of the most important of those treaties, the Lugano Convention? Well, the title of the convention gives us a hint. Convention on Jurisdiction and the Recognition and Enforcement of Judgment in Civil and Commercial Matters. This makes it clear that the Lugano Convention regulates jurisdiction and the recognition and enforcement of foreign judgments, but it isn't concerned with the applicable law. It doesn't regulate the applicable law. So this is what private international law is about. It's always about conflict of laws issues. And this is very different from substantive private law. We have to clearly distinguish between private international law and substantive private law. It's not the same. Private international law is concerned with the conflict of laws issues that are regulated in the Swiss Code of Private International Law and in a number of treaties, such as the Hague Conventions and the Lugano Convention. In contrast, substantive private law is what we can find in private law legislation such as the Civil Code, the Code of Obligations, or the laws on intellectual property. On the other hand, those two areas of law are also closely related in practice. Private international law rules determine the lex causae, so the applicable substantive law. This leads us to the next question in our program. The question of how to deal with conflict of laws issues in practice. The question of how to apply private international law rules. At this point, let's take another look at this example. What exactly are the private international law issues in this situation where XSA, based in Yverdon, Switzerland, delivers a machine to Y Limited, based in Jaipur, India, for an amount of $5 million? And let's assume that this machine has been delivered, but Y Limited refuses to pay the $5 million, saying that the machine doesn't function properly, which according to XSA is not true. Let's assume that XSA, of course, wants to recover that price of $5 million, and it considers suing Y Limited in front of a court in Yverdon. In such a situation, of course, we have to focus on three issues, namely jurisdiction, the applicable law, and recognition and enforcement of foreign judgments. And in this case, there is no treaty regulating those issues. It's not a cross-border transaction within Europe. It's beyond the scope of the Lugano Convention, which means that we have to go into the Swiss Code of Private International Law. So what can we find in the Swiss Code of Private International Law? Let's have a look at the structure of the code. There is a Chapter 1, General Provisions, that is also referred to as the General Part. There are chapters 2 to 11 referring to specific private law areas, and this is also called the specific part. It's the main part of the code. And this includes chapter 9 on the law of obligations, which contains a section 1 on contracts, where we can find the international contract law. And of course, this is most important for our case, where we have a cross-border transaction based on a contract between two business partners. In addition, we also have Chapter 12 on international arbitration. In practice, we have always to go first into the specific part in order to find specific provisions that could apply to the case. And only in a second step, we go into the general provisions of Chapter 1 in order to check whether there is an additional provision that could change something about the outcome. So what answers can be found in the Swiss Code of Private International Law for our case? As mentioned, we assume that XSA wants to sue Y Limited before a court in Yverdon, Switzerland. Is this an option? What about jurisdiction, the applicable law, and enforcement? I'd like to suggest that you reflect on those questions during your coffee break. Here is your coffee break task. Go into the 3 conflict of laws issues, and for every issue, try to find the relevant articles in the specific part and in the general part of the Swiss Code of Private International Law, and apply those articles to the case at hand.